as you go into any potential deal, that these are things that you bear in mind. So afterwards, by all means, I'm happy to actually provide to Bevan, who can provide to everyone like a little bit of a checklist. So I can do this later on tonight or tomorrow. But what I suggest for now is make your notes as I discuss these topics so that you've got them stuck in your mind as I discuss them. You complete them on a piece of paper, and like this, will give you the opportunity to explore them and ask these questions later when Bruce is around, and actually be able to get more information and flesh out this framework that I actually want to go through today. So the topic tonight is basically around JVs and around partnerships. Now, why am I qualified to speak about this? The main reason why I'm qualified to speak about this is because I'm 20 years in practice in the commercial space. So my function at BSA Law is commercial tax and deal making. I make deals happen. So whereas Bruce, for example, has a lot of commercial experience and approaches it now from a litigation perspective, I used to approach it from a litigation perspective, and now I approach it from a deal making perspective. So everyone to their strengths. Why am I different to your typical property attorney? Why is Bruce different to your typical property attorney? Because when you think of property attorneys, you think of conveyancers, right? And nothing wrong with that, but conveyancers typically focus on moving a property from A to B, right? I focus, for example, on the commercial side of property investment, making deals happen. Bruce, for example, focuses on the litigious side of property investment, where if there's issues, he either wants to foresee these issues or he actually wants to resolve them after the fact. So this is what BSA Law does. For the SAPN coaching students, this is the support that we offer at any event. Any of the information you get, be it from Bevan or Andrew, is usually something that's run either by myself, my conveyancer, Bruce, anyone in the team that's actually able to answer these questions for you. So that's just a brief introduction. Bruno, been in the industry for 20 years, entirely specializing in the commercial space, in the property space. There's very few things that I've not experienced, especially in this space. Now, to get to the topic at hand and trying to get you as much information as we possibly can. So the first topic that I want to go through is, what is a joint venture? Now, I approach this from two sides, right? You've got the business lens and the legal lens. Now, the business lens, what is a joint venture? I think most of you would be able to answer that for yourselves. It's basically when you approach some kind of business idea or an outcome that you want to share with somebody else, and you want to find a way of achieving this outcome with a partner, with even a spouse, whoever it might be, a friend. Now, that's the business side of things. But now we have to take a look at the legal side of things. What does this mean from a legal perspective? And what is a joint venture from a legal perspective? And the reality is, guys, there is no legal definition of joint venture. Joint venture is simply the act of doing something jointly, taking on a venture. Yes, it is defined normally within the business landscape of actually being able to have some kind of going concern happening, but there's no real definition. Why? Because a joint venture is not an entity or an association on its own. And this is where we need to take one step further. So when you start having this idea of entering into a JV, you need to ask yourself, what is the best structure for the JV? Now, I don't want to get ahead of myself because many of you out there are going to be asking, but what relevance is this? We should first be discussing like the general terms, how we'd enter into these agreements. Wouldn't that factor in what structure we decide? But it works the other way as well. See, we have laws in our country at the moment that have predefined rules for the different structures. So you want to make sure that when you're negotiating the terms of this JV, you actually have an idea in your mind what structure would suit you best. So I'll give you an example. A JV could be a partnership. So this is your normal typical partnership. You and your friend enter into a joint venture together. You guys are partners. One of the risks with partnerships is the legal liability behind it. If the partnership does something wrong and falls into debt, both partners could very well be held personally liable for the debts of that particular partnership. So the partnerships, there are ways of structuring it, and Bruce and I constantly have these debates on whether partnerships are really still an effective entity to use. Why? Because I'm a big fan of the corporate structure, which is your company. Why? Because the company already has the Companies Act in South Africa, and this has a whole set of rules that many of you may actually be familiar with, even though you don't realize. So this whole concept of shareholding and owning different percentages of shares and actually having a share in hand and being able to vote depending on the amount of shares that you have. So these are concepts that we use on a daily basis, and it makes things very easy. It makes JVs easier to run, makes businesses easier to run. So I'm a big fan of this corporate structure. There's a couple of other structures that one can consider. There's simply contractual agreements where you and me decide to collaborate on a project. There's no partnership. There's simply almost a services agreement. You do X, I do Y. At the end, when we receive payment, we divide it as follows, and we take our separate ways. That type of contractual JV is fantastic, except that it's a shorter term. So you would typically find that it would only last one deal. So you do a flip with someone, for example, you just have the contract and you guys would agree to share profits in a very specific way, and you'd walk away with the deal. Whereas if you use, for example, a company structure, it's long-term. It's built for those meetings. It's built to allow you to sell shares. It's built with certain mechanisms inside for dispute resolution. So that's just a couple of things to think about. And then the last one is the trust. I would never use that for a JV. You don't enter into trusts with people that you might not even know that well or that you're not related to, hoping that you have a JV, because exiting from a trust is particularly difficult. There's layers of complexity. Having a JV for you and having a trust for you and your family is a great idea for estate planning. It's an estate planning tool. It certainly is not a business tool. So in summary, what is a JV? A JV is an intention to go together into business. But how do you structure a JV? That really depends on your needs. Short term, get a contract, agree on certain things. Long term, maybe consider a company, have a share issue, and each person owns their respective amount of shares, and then you start having discussions about how to exit and that sort of thing. So that now brings me to the second point. Now, common JV terms, right? Now, this is very important because I'm going to deal first with the common JV terms, and then I'm going to speak about the terms that should be in JVs, but typically aren't included. Now, to be honest, between you and I, even these common JV terms, I often see them excluded. So when I say common, it better be drafted by someone that actually understands JVs a little bit, because if they don't, they're going to miss this out. And this is when I'm going to start asking people to start writing, right? Whether it's a contract, whether it's a company, doesn't really matter. These terms should be discussed. And I normally refer to these as commercial terms. And this is where you as a property investor need to step away from the legal, because that's what Bruce and I are for. We are the guys that are going to put this down on paper, make it work, and make sure that there's a contract that both parties are happy with at the end of the day. What I don't want is you guys to focus just on what the final outcome is going to be, the legal terms, and forget the commercial terms. This JV needs to make commercial sense. So what I suggest to all my clients is prepare a little term sheet. What does that mean? Term sheet. What do you want out? What does that person want out? Ask as many questions as possible, run through as many scenarios as possible, come to myself and we'll have a discussion, and I'll throw certain curveballs your way. What if this happens? What if this happens? And you can answer and tell me, no, that's not plausible, that's never going to happen. Or, Bruno, sure, I never thought of that. Let's go have a discussion with the other side. And honestly, between you and I, 50% of JVs probably fall through before they even start, simply because eventually when the parties ask the right question, they realize that they don't want to be in a JV together. Now, when would you want to have this realization? After you enter into a JV and now you guys own a property together, or before you enter into the JV, right? It's like marriage. Think about it. When you're dating someone, you want to know what all their flaws are. You want to know what sort of things that you're going to have to deal with and that you're able to deal with. If you're not familiar with those things and you get married, imagine what happens after that point. And I mean, we've all seen divorce rates all over the world skyrocket because people cannot tolerate each other anymore. And you're telling me that you're going to make a JV work simply because he's your friend or your family member or whatever. Maybe you went to school with the guy. No. Trust me when I say this. Stress test it at the beginning. If it's going to fail, make it fail at the beginning because you don't want it to fail once you're in it. So common terms, things that you have to have discussions over. First one, very basic, capital contributions, right? Money. Who's putting in the money, right? Now, people don't often realize this, but it's very important to have this discussion because one party might be the financier and the other party thinks that they're simply contributing some form of sweat equity. And when it comes later, think about it. And now some debt arises and no one knew that it was going to arise. And, we have to pay the municipality extra. We didn't think of it. Now the parties look at each other and go, well, actually, you're the financier, so you give me the money. And the financier goes, no, I gave the money, right? What I gave the money for, I got my shares. Now we're in this equally. So if this company is in debt, both of us are going to contribute equally or according to our shareholding in order to cover this debt. So conversations around who gives money is not just about who gives the money up front. It's about who gives the money, right? When is this capital contribution supposed to be pulled back? And when are we supposed to be having a conversation over dual contributions? And later, when I get to the more unique clauses, we might want to have a conversation over capital contribution versus loan, right? Because from a business perspective, this is a big one, right? A capital contribution buys shares. Now, one person puts in money, gets shares in return. The other one puts in sweat equity, or sweat rather, and gets shares in return. But now the guy with money says, well, I want my money back first. I want that loan repaid. So you guys, again, need to start asking yourself, but the guy then that put in the sweat, does he also then get something back? Because why is he putting in sweat and not receiving anything in return except shares, and this person's getting his entire contribution back and retaining shares? So again, conversations like that. Should the person that's putting in sweat actually be entitled to a salary, even if he doesn't take it in cash? Maybe it should be written up as a loan against the company so that he can get something out without having to, well, he'll obviously pay normal income tax on it, but at least then is entitled to a debt repayment, as opposed to try to only being able to share in dividends. So it's something to think about. You need to ask the question, capital contributions, who makes them? What is this person then going to be entitled to once he's made them? Does he carry any preference over the other guy? Now, many of you may ask this during the discussion. The assumption that in a JV, both parties contribute to the JV equally is something that's changed fundamentally in recent times. JVs, nowadays, what I'm noticing more and more is that there's knowledge that's being contributed to a JV. So the idea of it always being a monetary contribution is long gone, right? Now people contribute actual knowledge and know-how, and this carries a value. How much value it carries really depends on how the parties negotiate. So don't come to Bruno and ask, what percentage should I get if I contribute 100% of the capital to buy the property and the other guy is running the student accommodation? Should I not have a higher percentage than him, right? Or vice versa. I've had guys going, I found the sweetest deal. And all this guy is doing is contributing a deposit and standing in for a loan. So yes, financially, he's put everything into this deal. But number one, you stood in for a loan, so it's not a cash contribution. Number two, I'm actually doing all the work. Not only did I source the property, but I'm running it. And these are conversations you need to have with the other side, because usually in those instances, I try and associate a value. How much would a procurement of this property actually be worth? How much would somebody pay you to get this property? Great, let's put a value to that. Is this something that you can claim from the business later, or is this a value that you're contributing to the business? Fantastic. How much is your monthly contribution running this JV worth? Is this a salary that you would normally earn? Do you want to write it up as a loan, or are both parties happy that this be something that you acquired equity for? So capital contribution is very important. Think of the different options. Control and decision making. So outside of capital contribution and who owns this company, or who carries these rights in terms of a contract, a collaboration agreement, call it a JV contract, which is just contractual. Next question is, who controls it? So you've got this JV, so now you've created this business together, be it in the form of a company running a going concern, or be it in the form of a partnership running a going concern, or simply a JV that has common interests and each parties perform in terms of this common interest. The next question is, who calls the shots, right? If you're buying properties together, and that's why I said contracts don't work well long term, because if you're buying properties together, you're going to jointly own something. So at least if it's in the company owns it, and you have shares in this company. Whereas if you're trying to do this in a contract, you're going to be joint owners anyway. So it's going to be very difficult to exit, and you're going to need many terms in those contracts defining how you guys are going to deal with each other going forward. But either way, the control is an important element. Again, who runs this business? If it's a quick JV and you guys are planning on flipping, even the simplest question like, when do we reduce the purchase price? Because you know how many flips we've seen on the market where everyone optimistically goes to market with a purchase price of 2 million Rand, and 1 year later, they're still sitting on 2 million Rand. And this is when the fight starts happening, because no one had the foresight of having the discussion over when this value is going to start being reduced, because they just assume they'd agree to it. But one guy doesn't want to cave, and the other guy wants to start reducing, and no one had this discussion. So either you decide at the beginning of this little arrangement who's going to call the shots, or you're going to have mechanisms, which I'll discuss now, on how these shots are going to be called. So control and decision making, very important. Often with some of these JVs, guy puts in money, doesn't want anything to do with the operations. The other guy runs the operations. And I will actually have this discussion as well about director duties and oversight. So control and decision making. Now, again, all of this ties now into profit distribution. So we spoke about the capital contribution, what the people put in, profit distribution, who's getting what out. With shares, it's normally easily determinable. There are special ways you can have different classes, but to keep it simple, you have shares, you get certain dividends. But again, is one person getting the loan repaid first before dividends are going to be declared? What this means is, before there's profits, the person gets their loan repaid. If the person's getting their loan repaid, the other guy's getting nothing until that loan's repaid. So it's questions to ask over what comes first. Loans, profits, how these are going to be distributed. Again, percentages, very important. Day-to-day roles, this comes back down to control and decision making. Deadlocks. Deadlocks aren't a difficult thing to get through. Just make sure it's in the contract somewhere. So in a company, for example, you'd have a shareholders agreement that deals with deadlocks. So if you decide to have a 50-50% in this company, what happens if you guys don't see eye to eye? How do you resolve this? Now, you don't want to dissolve the company because now there can't be any agreement. So what do you want to do? You want to have a deadlock provision. Simple deadlock provisions: appoint someone, agree ahead of time that that guy is going to make the decision for us, any type of decision. So if we disagree on a business-related decision, we're going to go to that business expert. If we disagree on a legal-related decision, we're going to go to that expert. Deadlocks like that are actually quite simple, or you just veto or give someone an extra vote and say, if there is a dispute, maybe the third shareholder gets to cast the deciding vote. Something along those lines. You need to make sure that you don't get stuck on that 50-50 though. Exit terms, very important. How do you exit the deal? Not only how do you get rid of your shares, but how do you actually get rid of an asset in a company as an example, right? Because there's many different types of exits. So first of all, if it's a bad deal and you want to get out of this deal and you feel that the property should be sold, you can have a conversation where you set out certain rights, certain protocols on, at this point in time, the property must be sold because it's reached occupancy or less than, or it's now, running at a loss and it's run at a loss for 6 consecutive months, whatever the case is. So some people might want to force the sale of a property. Again, this type of exit, ask yourself, what's the difference? If I don't like the property, maybe I'll just sell my shares. But what if you own multiple properties and the other ones are great, right? And it's only that one that you want to get rid of and your fellow shareholders don't want to get rid of this. Don't you want to have the discussion ahead of time on how it's going to be decided? How will you decide if a property needs to be sold or not? And what protocols, what systems are you going to follow to reach that decision? Something objective that's not subject to discretion. Just set your rules up. And this is where I speak about metrics as an example, where if like the example that I gave now, if a property runs at a loss for 6 consecutive months, it's a given. And no one can dispute it. You have to sell that property because it's simply not worth it anymore. So those are just some couple of ideas on how to actually have a conversation around deciding deadlocks. I hope everyone's writing this down, because unfortunately, I do have to go through this quite quickly, because I could sit and speak about this for a whole day, but I'm just trying to give you guys ideas. So don't be overwhelmed. This is just so you're aware that these things exist and you're able to actually ask the right questions. And then, unfortunately, I'm sorry to say this, but you're probably going to have to see a legal professional anyway. But this just allows you to negotiate those commercial terms in an educated way. And then, so that's exit terms. And then time frame, again, like I discussed before, you choose your entity based on the time frame of the deal. The flip versus long-term holding versus holding, but not long-term, maybe only for 5 years, and then you want to sell after 5 years. Imagine the guy on the other side of the table doesn't realize that your intention is actually to sell, force appreciation and sell after 3 years. And he's thinking that he's entering into a 20-year deal, and you're thinking that you're entering into a 3-year deal, and no one's actually had the conversation over what the intention of this property is. So just think about things like that, very important. And believe it or not, these are the common terms. So going through forgotten terms. And again, I might not go into as much detail on this as I did on the other ones, because the other ones are more crucial. But they kind of interact with each other. So again, a preference for repayment of a debt. Shareholder contributes capital. Is that capital a loan, or is it actual capital for equity? Is there a preference for him to be repaid before any profits are declared? Think about that. Very important question, because now you don't want to get caught off guard. Time comes and he goes, no, but we said it was a loan. So I'm now taking from all these profits, I'm taking all these loan repayments. You're getting nothing until I'm repaid in full. Discussions worth having ahead of time. Guys putting in money, you also need to think about that. Are you actually going to get your money back? Because you might think it's a loan. You walk out with shares and then you realize, hold on, that is a capital contribution. And meanwhile, you're paying this guy a salary for doing his work, and you didn't realize that it wasn't a loan. There was no repayment terms. You were simply giving capital away. And the problem normally arises, not necessarily always when the company's running, because maybe the parties have an understanding. It's when people unfortunately pass away, and you don't have somebody you can rely on to back your story up. And now you're trying to fight with the executor of the other shareholder who's looking at this and going, sweet, I own 50% of this company, and everything that comes in is pure profit, and I'm going to claim all of it. And there's absolutely no proof that that person has any loans in this company because the accounts weren't captured properly. So now it's a fight between you and some stranger that you don't even know. So be careful with that. Always certain, are you planning on getting this money back as a loan, or is it a capital contribution towards equity or shares? Directors' duties and oversight. So this goes again to that control component. But if you're the fund or financier, please be warned. Please ensure that if you're allowing somebody else to run the company because they're more experienced than you in this particular business field, that there's oversight. There's always checks and balances. So you go to a legal professional. So I did this the other day. Went to a legal professional and I'm trying to close a deal between this guy putting in a lot of money, I think it was around 20 million if I'm not mistaken, and the guy that wants to run it, big building. And the guy putting in money kept worrying, like, but how do I know that my money is going to be used correctly? How do I know that he's doing his job? I'm trusting him a lot. And on top of that, he's asking for a salary. Is that fair? Yeah, you know what? Let's make it fair. Let's have accountability measures. I set up measures in that deal where every quarter, for example, we audited the occupancy rate. And we ensured that the occupancy had to be above X amount. So we had a specific company, not an auditing firm, like an actual rental agency that would audit occupancy. We audited the vetting criteria, whether everyone that was put on the property actually passed the right vetting criteria. We obviously did financial audits on income. Are we receiving all the income? Is our debtors book growing? Does the bank recon? So all the money coming into the bank, does it recon against the money that's showing against the rental roll? All of that. So we got professionals to recon everything. There was legal audits of lease agreements. Just make sure, because as soon as one of these auditors, and they're all auditors, right? As soon as one of them finds that we didn't hit that 80% or we hit a 30% delinquency or whatever the case is, immediately red flag goes through to the main shareholder who put in the money, and that shareholder can now take action. Another thing as well is if the person is running the business based on his expertise, tie him down to his expertise. So what is the expectation of this expert? Tie it down. You do it with a service provider. You mandate a service provider to perform A, B, and C, right? You set out the terms of that performance. You do the same. And I've had plenty of arrangements like this where it almost feels like an employment contract. You earn your shares and your equity by performing this. You're promising a certain outcome. You need to hit these targets in order to earn these shares. Again, not a difficult thing to have a conversation over, but it's just stuff to remember. We don't have to overcomplicate it, but you also don't want to undercomplicate it and then not have those mechanisms. So sometimes the middle ground is to simply state there that if the person doesn't achieve a certain target, stay shareholder, but you're allowed to step in and now deal with it and take it over and make the decisions. Whatever. There's always ways of doing it. It doesn't have to, again, to be overwhelming. Duties of non-financial parties, that I kind of touched on now. Dispute resolution touches on deadlock. So you want to have conversations over whether you'd mediate if something goes wrong. And if there is still a deadlock or if there's some kind of dispute, somebody does something wrong. Exit triggers, again, touches on your exits. But for example, in these instances, say that a trust is your co-shareholder and now all of a sudden, the whole trust changes, all the beneficiaries change, somebody else pretty much takes it over, or your co-shareholder is a company and there's a full shareholder change and it's no longer the people that you know. You might want to have triggers for exits to say, well, if you sell all your shares in your shareholding company, you're actually triggering a forced sale, which means that I can actually buy the shares from you and you can't say anything about them. And you can have in the contract, like, how do you agree to certain amounts and things like that. Then very important for people that are entering into JVs with experts in the field. Are they running other businesses in competition? And how do you determine what deals go where? Because now you've got this one guy who proclaims to be this master sourcer, but how do you know you're getting the right deals, the ones that he promised you, and getting the best deals? So that's also a conversation to have around restraining people from doing too much and possibly prejudicing this JV that you're having. All right, and then change of control, I discussed it now, so those are the exit triggers. So key takeaway, if you don't address the above, you're going to land up causing more damage to yourself than it's worth. This is a conversation you can have at the beginning of the negotiations, and you can set this out simply by going through these examples. These are the most common examples. So it's definitely something worth thinking about. And if Bevan would like, tomorrow I'd put together this and I'd send it through to everyone so they can have a look, and at least they've got a checklist to work from. But these are just some of the common things to look out for. I gave you some case examples as well, so I don't want to go on for too long because I know that people have questions that they might want to ask Bruce, but I did discuss certain examples where people enter into deals together and they regret it later. So definitely utilize this checklist or everything that I've given you now in order to think about the different scenarios, to prepare your commercial terms and to execute the deal.